Hello, I'm Jeffrey Hakanson. I am an attorney here at McIntyre Thanicides. So what's going to happen if you show up at a pretrial? Most of the times the judges will introduce themselves when you appear at the pretrial conference. There will be a lawyer for the creditor and you yourself standing alone in a courtroom of 150 people. The judge is normally going to tell you that you have three options. First, you can admit the debt and admit that you don't have the ability to pay, and the court will enter a judgment right there that day. The second option is usually to admit that you owe the debt, but you would like to pay and that you would like to have a repayment plan with the creditor. He'll give you an opportunity to go outside and see if a payment plan can be negotiated. The third option is to deny the claim and put the creditor to its proof. That being that the court will then schedule the matter for trial or send you to mediation. If you deny the claim, then you have an opportunity to put forward a defense. It's very important before you go to your pretrial conference that you understand what your rights are relative to collection in the first place. It's very important to understand what a judgment creditor can do to you. Well, they can't throw you in jail. There are no debtors' prisons in America. You may not be aware of state law protections that are created by the legislature or the Florida Constitution, which provide protections for consumers against the efforts of judgment creditors. For example, if a judgment is entered against you, a judgment creditor can normally garnish your wages. However, a judgment creditor can't garnish your wages if you qualify for the head of household exemption. This is something that you need to talk to a lawyer about to determine if this exemption applies and these protections apply to you. Additional exemptions that apply to the efforts of judgment creditors to collect against you are best exemplified by the Homestead exemption. Everybody's aware that their home is their castle in the state of Florida. Well, the Florida Constitution provides what is known as a Homestead exemption from the efforts of judgment creditors. A judgment creditor cannot enforce a judgment lien against your homestead. They cannot pursue collection of a judgment against your homestead. They cannot force the sale of your homestead in order to satisfy a pure money judgment. Now, this is not the case with the voluntary lien of a mortgage. If you have a mortgage on your property, it can be enforced against your homestead. But a simple judgment creditor cannot enforce that judgment against your interest in the homestead. It's also important to consult with a lawyer to find out whether a marital exception to a judgment creditor's efforts might apply in your situation. Generally speaking, if a judgment is entered against a single spouse, say for example a judgment is entered against a husband, that judgment cannot be executed, that judgment cannot be enforced against assets that are owned by the husband and wife within the marital estate, what is known legally as tenants by the entireties. It's important to consult with a lawyer to find out whether the application of this exception to a judgment creditor's remedies would apply to you. One of the most important state law exemptions that we try to make sure our clients are aware of is the exemption against collection of Social Security benefits, Social Security disability benefits, Veterans Administration disability benefits, or anything similar. Under Florida law, those benefits cannot be garnished. It's very important to understand whether or not your Social Security benefits or disability benefits apply and are covered by state law exemptions and protections from creditors. Finally, it's very important to understand whether any qualified pension and savings plan that you might have, an IRA, a 401k, or an annuity, basically household savings, whether any of those accounts can be garnished or seized by creditors. Florida law provides a variety of exemptions for those types of accounts, and it is essential to consult with a lawyer to determine whether those accounts are susceptible to creditors' efforts to collect on a judgment.